Welcome back to our group study review. We are on to another hypothetical, and this time it is evidence. Okay. So I'm going to start with saying, again, there's part one is the criminal trial, part two is the civil trial. For part one, we are going to be questioning a report and statements.
Okay.
A report, statements, and expertise. And then for the civil trial, we are going to, I'm just going to leave it at that.
Okay.
And we're going to take on the hypothetical without the questions. Again, this goes completely antithetical to what I say you normally should do. But that's how it's going to be for a full evidence hypo.
Evidence. Totally makes sense.
Yeah, and in this, remember you guys, it's the evidence is part of your MBE, right? The full questions, the multiple choice questions and answers. And that's a lot of what you're looking for. It is not normally an entire hypo by itself.
No.
It certainly can be, and it's not beyond the pale to be, but normally evidence is going to be in those MBE questions and maybe a part of a question for something else, where it's your criminal law, which is why I'm reusing the criminal law one. It's part of your criminal procedure. They're going to go through that and then say, and can you admit the evidence at court after a suppression hearing? So it's going to be related to that. The criminal trial. You ready?
Yes.
Part one, Bob and Alan went on trial together for the murder of their coworker. By the time of the trial, Charlie had killed himself and was no longer available to be prosecuted or to testify. The prosecution...
Of course he's not available.
Of course. Why would he be available?
Right. We had to have an unavailable declarant, didn't we? We just had to.
I mean, you have to. We got to do that part of hearsay. Well, the prosecution in this case still seeks to introduce several pieces of evidence against Bob and Alan. And we're going to go one by one on this. I'm not going to let you choose to pick and choose around because of how it's set up. But here's number one. The prosecution seeks to introduce the medical examiner's report that the coworker died from a gunshot wound to the chest. The medical examiner was not available to testify at trial because she was overseas at an international conference at the time of the trial. However, the medical examiner had already testified about her report and her findings during a deposition related to the widow's civil wrongful death suit against the factory. Can the report be introduced? And if so, how?